U.S. District Judge Tanya S. Chutkan on Friday issued a stunning rebuke to four-time indicted former President Donald Trump, rejecting his Jan. 6, 2021 motion to dismiss the charges on absolute immunity and other misleading constitutional grounds. The ruling came just hours after an appeals court rejected Trump's request for immunity in a parallel civil case. Chutkan's ruling could be the most significant legal defeat yet for Trump and possibly a decisive turning point in the 2024 presidential election. Chutkan brushed aside Trump's claim of criminal immunity, arguing emphatically the text, structure, and history of the Constitution do not support that claim. No court or other branch of government has accepted it, and this court will not stand that. He continued, whatever immunities sitting president enjoys, there is only one chief executive of the United States at a time, and that position does not allow for lifetime get out of jail. He added former presidents are exempt from federal criminal charges. They have no special conditions regarding their liability. The defendant may be subject to federal investigation, indictment, prosecution, conviction and punishment for criminal acts committed while on duty. Looking at text, structure, and relevant history of the Constitution, Chutkan argues that Trump's claim of immunity criminal case is similar to Nixon v. He has made it clear that he is much less likely than a sitting president to be in civil suit. As noted Fitzgerald case, unlike a civil case against a sitting president, there is no concern here that prosecution would interfere with any official duties. Moreover, the risk of prejudicial litigation is greatly reduced because of the protections afforded to criminal defendants. Chutkan deftly quoted George Washington in affirming public interest in prosecution, the idea the power and right people to form government presupposes duty every individual to obey established government. As for historical precedent, he noted that claim absolute immunity from criminal prosecution has never been sustained. Judge Chutkan's decision is quite simple. Solid as a rock and sharp as tempered steel, constitutional expert Laurence H. Tribe told me. Aided by the circuit's unanimous rejection a few of our entire system of government rebels. Against this, Chutkan also brushed aside Trump's bogus First Amendment claims, arguing that Trump was being prosecuted not for speech but for the attempt to overturn election. He noted that speech that encourages criminal activity is not protected. Likewise, the case does not represent viewpoint discrimination or an attempt to criminalize a call government action because, again, he is being prosecuted not for his views but his illegal efforts to overturn the election. Chutkan later rejected Trump's frivolous claim of double jeopardy based on his impeachment trial. First-year law students understand that impeachment is solely about the ability to hold office and